Welcome everyone to Let's Collaborate, Compliance and Human Capital Solutions Spotlight State Leave Law Requirements. Thank you all so much for joining us. Chase Cannon will be answering the questions you sent through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we're unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'll hand it over to Chase Cannon, Senior Vice President and Deputy Chief Compliance Officer of Benefits Compliance at NFP. Chase, the floor is yours.
Amber, thank you so much for the intro. Thanks for organizing our call today, and thanks everybody for joining. My name is Chase Cannon. I lead our benefits compliance team here at NFP, and we're always working hard to get the best content in front of our audiences and trying to tackle the topics that are the most challenging for our clients and employers out there. And so today's presentation is really exciting. We're going to be tackling a topic that is just, we hear about this all the time, and it's just been increasing in complexity and nuances and challenges over the last 5 to 6 years. And so that is obviously state leave law requirements. And in a little bit different format today, we're going to be tackling this with some help from our friend Maria Trapanesso over at our Human Capital Solutions practice here at NFP. Because this is such a challenging topic and it bleeds sort of between compliance and HR and employment laws. And so that's really where Maria will come into play. But before we intro our presenters today, just really quick legal disclaimer that the following is intended to be used for general guidance purposes only. It's not intended to constitute tax or legal advice, and any question of application of the law should be addressed to legal or tax counsel. The information we're going to be talking about today is current as of today, which is April 17th, 2024. So with that, I want to introduce our 3 presenters today. Yoko Yoon is a benefits compliance specialist here on the NFP benefits compliance team. She's been with us for a while now and is just a tremendous resource, particularly with everything compliance, but particularly with our state issues that we come across, and is sort of viewed on our team as a state compliance specialist. Helps with all of our publications across the board, and really has been a big contributor on our resources with respect to paid family leave and mandated disability across the states. Shauna Walden is also with our benefits compliance team. She plays a role out in the field a little bit more, but has been with NFP and a company before we acquired them in a compliance role, and also just has this really strong view and practical application when it comes to compliance issues for employers. And so we're really grateful to have her perspective today. And then I mentioned Maria's name, Maria Trapanesso, who's our national practice leader for Human Capital Solutions, and really has just been a tremendous resource for us in compliance as we try and navigate this web of laws and challenges across the state leave. We consult with Maria quite a bit on other issues related to, that sort of bleed over into HR and employment law and human capital issues as we work to answer questions for our clients. So with that, I'm going to turn the call over to Yoko, who's going to walk us through the agenda and get us started here. Yoko.
Great, thank you, Chase. So we're going to talk about today the overview of PFML, the current state big picture. And we're going to go through several state-specific leave scenarios to make things more practical to the HR clients, how that coordinates with the FMLA and your employer leave policies. And we're going to also touch on the important upcoming state PFML, Delaware, Maine, Maryland, Minnesota, so that you're aware of what to prepare now for the upcoming states. And it will conclude by the employer action plan and key takeaway. So first, we're going to talk about the overview. So you see this US map. The yellow stars, as you can see on the US map, are already in effect. They've been running for a while, except for Colorado and Oregon are relatively new. And then you see the stars in red. Those are upcoming ones that are take effect mostly in 2025 and 2026. And then there are currently 12 states that are in effect already, including California, New York, DC, Oregon, as you can see. And unlike state health insurance mandates, this applies to all self-insured and fully insured. And also, even if you have one employee working remotely from home in that state. So it's important for you to kind of take a look at the employee census to see where they work, except for Delaware. Delaware has a special rules, but except for that, most of the other states have a requirement that if you have at least one employee who work in the state, that you are subject to the state's PFML. And what that means is that even if you have one or two employees work there from home, you have to register with the state, and you have to collect employee share of contribution. And you also need to do quarterly reporting and remit the premium to the state. And there are notices and poster requirements. So those are important. And you can also have, you also have an option for certain states to do a private plan, but even so, STD alone is not sufficient to be in compliance with the PFML. So it's important to understand those requirements. And this slide shows, like, we get questions often that what are the requirements and what our employer get to choose whether they want to implement or not. So the what's mandate is that those states that we looked at it in the previous slide are mandating the disability insurance and PFL, also called PFML and FMLA. Oh, and an FMLA, and some states have a state version of FMLA. And then basic leave law. So those are requirements that employers do not have a choice but to be in compliance with. And it requires usually the providing the maximum duration. There are specific qualified reasons. And then FMLA states leave, and some PFML provides employees rights for entitlement for the job protection and continuation of health benefits. So those are really important to understand which leave are entitlement, so that you can make sure that certain leaves are for sure job protected and continue their health coverage. And then the second piece is the optional. Many employers implement and provide STD, LTD as voluntarily if they want to, and other parental leave, caregiver leave. So you don't have to provide it, but it's good to increase the employee's morale. And an employer has a lot of leeway to design their own policies. But I think the upcoming scenarios will give a very important coordination with the mandatory leave as well as optional. And the last, just to go quickly on this, so we cannot emphasize enough, it's important for all employers to have a leave policy to indicate clearly how that your leave policy, STD, LTD, maternity, parental leave, and those will coordinate with the applicable states PFML and FMLA if applicable. And also certain cases, FMLA 12 weeks may be extended longer depending on the qualified reason that are covered outside of FMLA but covered under PFML. And I'll hand it over to Maria to go through some state-specific scenarios.
Thank you so much, Yoko. Now we're going to provide you with an overview of a few specific state leave scenarios. We're going to start with an overview of the regulations, and then we're going to follow it up with a chart of how the regulations actually work together with other leave programs. So let's start with the hardest first. We're going to take a look at California. So if you have at least one employee working in California and meet the quarterly payroll threshold, which is not really hard to do, you will be required to follow the regulations for state disability insurance in the state of California. Commonly referred to as SDI, it provides disability insurance for an employee's own illness or injury, and also provides paid family leave benefits for the purpose of bonding with a newborn, adopted, or fostered child, caring for a seriously ill family member, or to participate in a qualifying event because of a family member's military deployment to a foreign country. So in order for employees to actually receive the benefit, they must have earned at least $300 during a 12-month base period in which SDI deductions were withheld. The base period is the first 4 completed calendar quarters of covered employment. California SDI funding is fully paid for by employees through salary deductions. As most of you may be aware, in January of this year, California removed the taxable wage cap for disability insurance, which means that the 1.1% contribution rate for 2024 is actually applied against all earnings. In 2023, the rate was 0.9% of taxable wages, and there was a cap. There was a maximum wage base of $1,378.48 per year. This is a huge change for employees, especially for your high earners. So this change was actually enacted to help support the increase in state disability benefits to 63 to 90% of average weekly wages that's going to become effective in 2025. But a lot of employers are kind of like having a difficult time swallowing this change. The maximum benefit an employee can receive today is 60 to 70% of their average weekly wage, and California takes the highest quarter earnings from the base period to determine the benefit. So the maximum weekly benefit is $1,620 for 2024, which is actually the same as it was for 2023. And just a note here, the EDD, which is the Employment Development Department, is the governing agency for SDI and PFL. Their website has a disability insurance calculator that you can access online. And all you need really is to have the employee's monthly wages for the past 12 months handy, and it will provide you with the estimated benefit for the employee while on leave. I know I really rely on this, and a lot of employers find this website very helpful when assessing the amount of wage replacement benefits an employee is going to receive from the state. So when we look at the maximum duration for STI, it is 52 weeks for disability insurance and 8 weeks for paid family leave. Leave under both of these regulations can be taken continuously or intermittently. And although California SDI and PFL is an insurance benefit and does not offer job protection, other benefits that run concurrently with this type of leave may offer those protections. And if you take a look at the right side of this slide, we just wanted to call out a few key notes. In accordance with the Paid Parental Leave Ordinance, or also called PPLO in San Francisco, employers who have 20 or more employees worldwide will need to provide supplemental compensation to employees bonding with a child, in addition to any compensation they receive from California paid family leave. That means that in order to be required to comply, the employee must be on benefits through the paid family leave, the PFL. This means that you will have to top up the California PFL benefit for San Francisco employees up to a weekly maximum of $2,700 per week. Now, that does change annually. So if you're in San Francisco, just make sure that you check that cap amount each year. The California PFL and the federal FMLA have different definitions of covered family members. So it's really important that you take a look at whenever an employee is eligible for or possibly eligible for both leaves, because there may be times when an employee is eligible for one and not the other. And I'll give you an example. California regulations define a domestic partner as a covered family member, but federal FMLA does not. So if an employee is taking leave to care for a seriously ill family member and they're a domestic partner, they're only going to be covered under the California PFL and not the federal FMLA. That means that they're going to still have federal FMLA to take throughout the year if they haven't met their 12-week allotment. So I also just wanted to make a note for those of you who may be state employers. There are specific provisions under the non-industrial disability insurance in California for disability and family care leave that you need to be aware of for your employees. And we've included a link at the end of the deck so that you can have more information on this. So let's first take a look at how maternity leave works in California. We are going to show you maternity leave and bonding leave, but it's so complex that we wanted to start with maternity leave. So this is an example of a 6-week maternity leave for natural childbirth in California. The example makes a few assumptions, and one of them is that this employee is eligible for FMLA, and the employer offers a company-sponsored short-term disability plan. So let's take a look at how all of these regulations work together. Under 1A, which is the beige bar, you're going to see that employees in California are permitted to go out for up to 4 weeks prior to the birth of a child for a non-medical related leave. That's right. I said non-medical. That's how California treats its employees very well. So an employee would actually receive wage replacement benefits for this period of leave under California SDI after an initial 7-day unpaid waiting period. It's really important to note that during this time, the employee is not going to be eligible for FMLA or California pregnancy disability leave because it's not related to a disability or covered reasons under those regulations. So if an employee did have a medical need to take off prior to the birth, this chart would look very differently. The California PDL, which is the brown bar, number 3, and the FMLA blue bar, number 4, would begin at the onset of the leave because the disability or medical condition of the employee would be considered a covered reason under these 2 regulations. So number 1 is the orange bar, and this example shows California short-term disability, California state disability insurance for a period of 6 weeks for natural childbirth. Generally, for natural childbirth, SDI provides 6 weeks of paid benefit and 8 weeks for C-section. Paid benefits begin again after a 7-day waiting period. And in this example, we're showing you the waiting period that occurs at the onset of the pre-birth leave claim. But if the employee is starting their claim post-birth, then they would be subject to the waiting period once they give birth and start their claim. So again, that waiting period, that 7-day waiting period is always at the onset of the claim. Number 2, the greenish blue bar shows how the employer-sponsored short-term disability runs concurrently with the California state benefits. It's really important to note that the state is always the first payer. And what that means is that the insurance carrier is going to consider what the employee receives from the state first, and then they're going to pay the short-term disability benefit in accordance with the employer's policy. Now, we all know that the California SDI benefit is very rich. So depending on an employee's weekly wages, there may be times when the employee will not receive an STD benefit from the employer-sponsored plan. And I'll give you an example. If an employer's STD plan provides 60% of an employee's wages up to a maximum of $1,200 a week, it's feasible that an employee could receive more from California since the employee is eligible for 60 to 70% of their weekly wage up to $1,620 a week. So it's very important that if you, and California is not the only state where this is applicable. This could also happen in other states that have a rich benefit. So it's really beneficial that you speak to your NFP consultant if you want to review your short-term disability options. And of course, if you don't offer short-term disability benefits to your employees, then only California SDI applies. So number 3, the brown bar, is California pregnancy disability leave. And this leave actually provides up to 17 1/3 weeks of unpaid job-protected time off for employees who have a disability related to pregnancy. This is applicable for employers who have 5 employees or more working in California. California PDL will run concurrently with FMLA, short-term disability, and California SDI benefits, and needs to be substantiated by a physician statement. In this example, the employee is approved for 6 weeks for maternity-related disability. And California SDI may also be taken prior to the birth if it's medically necessary. Number 4, the blue bar is, of course, federal FMLA, and this is going to run concurrently with the maternity portion of the leave. As you can see, this employee will use only 6 weeks of the 12-week FML allotment. An employee may be eligible for up to 12 weeks of unpaid job and benefit protected leave under the FMLA. And right here, just a note, it's really important for an employer's policy to state that any FMLA leave is going to run concurrently with all applicable internal leave programs and or state leave laws whenever the employee is eligible under multiple regulations. This is going to prevent employees from stacking time. And what we mean by stacking time is that if you see that these are all running concurrently, if you don't stipulate that in your policy, what's going to happen is that an employee could conceivably take the SDI and the employer's STD plan and then take FMLA at a later date if you're not requiring them to start that clock ticking on FMLA. So that's very important. It's also important to ensure that your policies and your practices require the employee to file for all state leaves that are applicable to them. Because if you don't require them to file for the state leave, then again, you're not starting that clock ticking on that employee's leave. And also there's benefits that you're going to be leaving on the table for that employee. So now let's take a look at how this coordinates with bonding leave. We just reviewed the maternity portion of the leave. This maternity portion is going to look a little bit differently. What we did is that we assumed that the employee is not taking off that 4 weeks prior to the leave. And as you can see, their waiting week, that waiting period is going to start at the onset of the California SDI insurance. So again, this is going to show you how the bonding portion of the leave dovetails after the 6 weeks of SDI, STD, and California PDL. So again, this example assumes that the employee is taking off for a natural childbirth, and then the employee began their leave at the onset of the birth. So you're going to see that now FMLA, California PDL, also begin at the same time as the SDI and STD because they're all for medical reasons. So that's 1, 2, 3, and 4 will run concurrently. Because this is considered the period of disability. After this period is over, in this case, the 6 weeks for natural childbirth, that is when the period of bonding begins. So we're going to start right now taking a look at number 5, which is the purple bar. And I could just say right here, just a note that a lot of employers get this wrong. A lot of employers will start their parental leave at the onset of the birth. And you have to remember that these are two distinct leaves. The birth and recuperation is considered disability under the EEOC, and that is separate and apart from bonding time, which is for all parents and for all reasons. So again, let's take a look at number 5. That's the purple bar, which is California paid family leave. And this provides a maximum of 8 weeks for bonding with a child. Again, the maximum weekly benefit is $1,620. Although California PFL can be taken intermittently within a 12-month period of the date of the event, this example shows the employee taking PFL right after the birth and continuously. So here's also that note for California, San Francisco employers with more than 20 employees. If your employee is eligible to receive that California PFL, again, you need to top up the amount that the employee is receiving from California paid family leave up to a cap of $2,700. So basically, you're going to be making the employee whole. And I will say a note here as well. If you have a parental leave program that is going to top up the California PFL, most likely you're going to be covered in San Francisco. Number 6 is the green bar, and this is the employer-sponsored paid parental leave. In this scenario, the employer is going to provide 6 weeks of the paid parental leave for the employee to bond with the child. And when this is the case, the employer's policy, again, should state that their parental leave program is going to run concurrently with FMLA, federal or state FMLA, and any other applicable leave laws. Because what's going to happen in this instance is that if you run it concurrently, then your paid parental leave is going to be a top up to what the employee receives from California PFL. And again, you can use that calculator that's on the website to figure out what that employee is receiving. Or we do have a lot of employers that will just assume the maximum for those employees until they receive the award letter and then true up with the employee. That's always the safest way to go, rather than expect the employee to pay you back money. So remember, again, the first is always the state payer, so you want to take that into consideration. And the reason why we suggest that you do it this way is because if you're not requiring the employee to file for that California PFL, you're leaving money on the table. That means that your paid parental leave is going to have to pay that employee 100%. Why pay the employee 100% when you can just top up what they're receiving from the state? It just makes more sense. And finally, number 7, the pink bar is the California Family Rights Act, or also known as CFRA. And employers in California who have 5 or more employees are required to provide eligible employees with up to 12 weeks of unpaid job-protected leave to bond with a newborn. So CFRA will always run after the period of disability, which is the SDI and California PDL in the instance of childbirth. CFRA runs concurrently with FMLA, California PFL, and San Francisco PPLO. So I know that was a lot. We will give you the slides after this, and I'm going to turn it over to Yoko to speak about Colorado.
Thank you, Maria. To switch the gear, we're going to talk about the Colorado FMLI. They call PFML that name. So Colorado PFML applies for all the employers who have at least one employee who work in Colorado. And this is a relatively new program, and that rolled out to the employees to able to take benefits starting from 1/1/2024. And one thing to highlight here is that maximum benefits amount, as you can see here, is 90% of an employee's average weekly wage. Up to for this year, $1,100. So depending on other benefits that your employer benefit may have, STD or parental leave, that'll usually top off this Colorado benefits to up to the full salary. And another things to note is that generally speaking, the combined maximum benefit duration is 12 weeks per year. So that is similar to the FMLA. However, if an employer experiences a complication from pregnancy or childbirth, then additional 4 weeks will be provided. So there might be a case that up to 16 weeks per week, you may need to provide that leave. And one quick note, this is we've been getting a lot of questions from the employer clients about this. So this is only a unique rule only for the 2024. Because it rolled out in 1/1/2024, and Colorado PFML bonding leave allows employees to take bonding leave within 12 months from the birth or a newly placed adoption foster care. Therefore, there might be a case that you already provided FMLA and your employer bonding leave to your employee. For those employees who gave birth or newly placed adoption foster care in 2023, they may be able to take another bonding leave for the same child in 2024, as long as it's within the 12-month period, if that makes sense. Thank you. And this is the example we're going to go over for the Colorado is a caregiver leave. And this example assumes that employee would take 2 weeks of intermittent leave, a total of 8 weeks out of the 12 maximum bucket that they have. And then this employer provides caregiver leave a total of 4 weeks per year. And as you can see, after the 4 weeks, Colorado PFML and employer's caregiver leave runs concurrently. So for the first 4 weeks, employer's caregiver leave benefits or top off to supplement the Colorado PFML benefits, unless that employee salary is meeting that benefits alone. And then in addition, this example assumes that this employee is also eligible for FMLA. Therefore, employers should designate the FMLA qualified reason, say, to provide care for parents' serious health condition. So FMLA will run concurrently. And now I hand it over to Shauna to talk about Massachusetts PFML.
Thanks, Yoko. So we're going to spend a little bit of time looking at Massachusetts paid family and medical leave, which I'll continue to refer to as PFML. It has been in effect since 2021, and it is one program that covers multiple qualified leave reasons. So leave for one's own illness and injury, which is what we're going to focus on in just a minute, but also bonding, caring for a family member with a serious health condition, and certain military exigency type leaves. Covered employers under the Massachusetts PFML are most employers with at least one employee working in Massachusetts. We do have a list, or excuse me, a link later on in the slides under our resources that do list out who these covered employers and employees are. To be covered under the plan or eligible for leave, employees have kind of two thresholds they need to meet. So they've either got to be a current Massachusetts employee, a self-employed Massachusetts employee or individual, or a former employee in Massachusetts that has been unemployed, that is unemployed, but has been unemployed less than 26 weeks. So that's kind of the first piece. And then there's also under bullet number 2, an earnings requirement that has to be satisfied as well. As far as paying for the program, contributions to the medical leave piece are generally split between employers who have 25 or more Massachusetts employees as a percentage of wages capped at the Social Security taxable income limit. So this will fluctuate and change annually, and the 2024 limit is noted there as 0.88%. Employers with less than 25 employees do not contribute to the program at all. And even those employers with 25 or more employees do not contribute to the family leave portion of the program. So we have that noted out there. When employees are taking leave, the maximum amount that they are eligible for fluctuates annually. And in 2024, it is 64% of the state average weekly wage, which maxes out at $1,149.90. As I mentioned, there are different reasons for taking leave, and so each reason also has a max allotment of time that you can be away. We're going to focus on an employee's own serious health condition in just a minute, which maxes out at 20 weeks. But just note that if you're taking leave for any of these conditions, there's a combined max of 26 weeks. So if we take 20 for our own personal health condition, we've got just 6 left to care for a family member or bonding or any other qualified leave reason. There is both job protection and continuation of benefit rights embedded in the Massachusetts PFML. We have a couple of notes on the side, but one that I definitely wanted to go ahead and point out is new for November 1st of last year. Employees may choose to supplement or top off their Massachusetts PFML benefits with any accrued and available paid time off. So this is the employee's choice, not the employer's choice, to kind of bring that 64% of the state average week benefit, up to their normal earnings, but not to exceed 100%. So here we have our example. It's a pretty straightforward, employee taking leave for their own illness or injury. There are some assumptions being made here as well. So we're going to assume that you're an employer who offers an employer-sponsored short-term disability plan. And we're also going to assume that the employee has met the eligibility parameters for federal FMLA. So assuming all those things are true, you'll see that the Massachusetts PFML is going to run concurrently with any employer-sponsored STD program, and that both programs have a 1-week waiting period before paid benefits begin. So they're still protected or covered by these plans during that waiting period. They're just not being paid during that time. Oh, if we want to just go back for 1 second, sorry. I just wanted to make a note that we kind of talked about on the slide before, but we're using the amount of leave here for 10 weeks. So we do have that remaining allotment of the 16 weeks for PFML, 2 weeks of FMLA to use at any point during the 12-month period that is defined by the employer's policy. I think we're all set. So now we're going to take a look at New York. In New York, we have 2 leave programs that are covering different scenarios. We have New York State DBL for one's own illness or injury, which has been in place largely, maybe wholly, unchanged for 75 years. We also have New York State PFL, which is in its 7th year of implementation, and it's covering leave to care for a family member with a serious health condition, bonding leave, and military exigency scenarios. The 2 programs, they're covering different things, but they have more differences than similarities to them. One thing that we see the same is who a covered employer is. So it's all private employers with at least 1 employee working in New York, and New York public employers may opt in voluntarily. See, from there, we just start to see more and more differences between the 2 programs. So we can see when we look at it in total that New York paid family leave is really the more rich or the more generous benefit, except maybe for employee eligibility and maximum leave duration. And what I mean by that is under New York State DBL, an employee is eligible to take leave when they have worked 4 consecutive weeks for any covered employer. So if I'm working at employer A and I give my notice and 2 weeks later start at employer B, I'm immediately eligible to be covered under the disability plan because I haven't had an absence of more than 4 weeks. Under New York PFL, under New York State PFL, eligibility for full-time employees does not kick in until you have been continuously employed for 26 consecutive weeks with the same New York employer. So again, if I'm working for employer A, I give my notice, 2 weeks later, I start with employer B. I have to wait 26 weeks, which is roughly 6 months until I'm eligible to take leave under New York PFL. Funding for the program is also different. Under New York Disability or DBL, the contribution rate is split between the employer and the employee, but the employee piece cannot exceed 60 cents per week. Under New York PFL, it is intended to be 100% employee paid, and the rate is set annually by the state. In 2024, the annual rate is $333.25 per year, or at least it can't exceed that amount. This is probably where we see the biggest disparity between the 2 programs is the benefit amount. Under New York State Disability, the highest weekly amount that a person can receive is $170, where under the New York State paid family leave, when we're taking leave, to care for pretty much anybody but ourselves or bonding or those kind of scenarios, we're getting a much richer benefit, 67% of the annual wages, which for 2024 caps out at roughly $1,150. So again, it's something that I think is being worked on through legislation to try and bring those benefit programs closer to each other. But as it stands right now, big discrepancy between the benefits that are received there. New York Disability does not have job protection or continuation of benefit rights, but New York Paid Family Leave has both. And if we want to move on to look at our a couple of keynotes. New York State Disability and Paid Family Leave cannot run concurrently. And that's, of course, because they're covering different scenarios, right? DBL is for your own illness or injury. PFL is for a family member or for bonding. So they do not run together. But in the case of maternity, which we'll review shortly, they do run consecutively. They do share a total max leave, annual max of 26 weeks. And with similar to the other leave programs, both should run concurrently with FMLA for the same qualified reasons. So if we want to look at our specific example, which is the one we most commonly see here in New York, causing confusion for employers, it is how New York State Disability, New York State PFL run alongside any employer STD or parental leave programs and the federal FMLA. So again, making a number of assumptions here. First, that the employee is eligible for all three programs. You know, we saw the 4-week eligibility period with DBL, the 6-month with PFL, and the 12-month with FMLA. So this is assuming you've hit all of those. It's also assuming that the employer has these two policies in place. So here we have a mother who is going out 6 weeks of leave for natural birth of a child. The New York State Disability is going to cover that portion of the leave alongside the employer's short-term disability policy. Both of those programs, again, as we saw in Massachusetts and California, have the 1-week waiting period where benefits are not paid. After that, the mother in this scenario is going to move on to her full allotment, 12 weeks of PFL for bonding. I'll jump back to kind of the options here in a second, but again, in this scenario, she's taking it immediately following the recovery from childbirth and will be out for a full continuous block of 18 weeks. The first 6 weeks of the bonding leave are going to run alongside an employer's parental leave. And there is the option in New York State, as I believe was addressed in California, to receive, for the employer to receive the PFL payment directly from the carrier when they are paying 100% of wages. So just a box that you check on the form, we will be paying full wages. That payment would come to the employer during that first, week 7 through 12 of the leave. And then after that point, the payment would go directly to the employee. All of that, of course, is going to run alongside FMLA whenever possible and available. So where it gets interesting in New York with PFL is that this scenario is depicting, full 18-week maternity leave, but New York PFL for bonding is available at any point in the first year following birth. So the mother could take it continuously, as we see, or she could say, after week 12, she's going to bank 6 weeks of leave and take it later in the year. So she can bank that leave, take 6 weeks off, 4 months down the road. She can take 12 weeks of leave, use that remaining 6 weeks to come back to work on a reduced schedule. So she can say, I'm coming back after 12 weeks, but for the duration of my 6 weeks I have left, I'm not going to work Thursday and Friday because those will be my bonding days. And that is okay. She could be out on leave for 16 weeks, save 2 weeks, use them to bond at the beach in the summer with the baby and her family if she chooses. So again, all of those options are perfectly allowable as long as they take place within that first year of birth or following birth. In addition, a mother in New York can choose to take that whole purple New York PFL section, slide it down and have it begin immediately following birth or at any portion of that orange leave DBL scenario that we see. Now, why would somebody do this? If you are an employer who does not offer employer STD, then you have a mother who's out on leave earning $170 a week, which might not be reasonable or feasible. And so she would like to forego, I guess it's not forego, it would kind of be advancing the benefit and choose to take the PFL instead. It's going to give her a shorter amount of leave. So we're going to max out at the 12 weeks, but it will all be paid at 67% of wages versus the $170 week under DBL. So again, all options, all up to the employee, none of which can be limited or denied by the employer. So hopefully that helps a little bit. I'm going to turn it back over to Yoko to review some states with upcoming new leave requirements.
Thank you, Shauna. So we're gonna hit up, there are 4 states that are already in effect, enacted and with the future implementation dates, Delaware, Maine, Maryland, and Minnesota. The first one is Delaware. And the payroll deduction will start from January 1, 2025, and benefits will be available to employees on January 1, 2026. But there are a lot of things that employers who are subject to Delaware PFML needs to consider and take an action this year in order to prepare for the launch of 1/1/2025 start date. And Delaware PFL is very unique in many ways. First is, as you can see under the covered employers, if you have 1 to 9 employees who primarily work in Delaware, then you're not subject to this requirement. However, if you have more than 10 employees in Delaware, then you're subject to Delaware PFML. And from there on, depending on the group size, which line of coverage are are required, depends on the group size of the employees who work in Delaware. And there are other special rules that possibly out-of-state employees can be reclassified and included as a covered employees. It's a very complicated and unique rules. And another unique rules is that maximum benefits duration is much, much shorter compared to other states' PFML. For example, combined maximum 12 weeks per year, which is basically the same as other states. However, other than the bonding leave, other qualifying reasons, for example, employee to take their own serious health condition leave or to care for family member, employee gets to take only 6 weeks every 2 years. It's a very unique law. And if you have any question about Delaware, please contact us. We have resources. We're more than happy to assist. And next state. Next state is going up to the Maine PFML. Payroll deduction will start from next year, 1/1/2025. And then also benefits will be available to employees on May 1st, 2026. So the time gap usually is that for the state to collect and reserve so that they will have a fund before the benefits will be available in the 1 year or 1.5 year date. And Maine is very standard compared to the others, very similar to the other states' PFML model, as you can see. And one thing that I forgot to mention is that Delaware, Maine, and other upcoming states, this is a good time for you to think about whether state-based program is all right for you, or you may want to explore and learn about the private plan option that usually run by the disability carrier and they coordinate STD, but there are differences too. And then also one thing to really emphasize is that if you choose to do a private plan, not the state-based, every single private plan needs to be approved by the respective state. And there's no one private plan that applies to across all states. So there's no cookie cutter plan that can fit into all the states' PFML requirements, unfortunately. So if you have unfortunately, if you're an employer with the multiple employees in multiple states, you have to get the approval or register with the state and go with the state-based each individual state. And going back to the Maine, So very basic, all the information is there. And the next state to hit is Maryland. This is something to keep an eye out for because as of now, the payroll deduction is scheduled to start on October 1st this year. However, and then as of now, the benefit is supposed to be available to employees by 2026. However, there is a proposed change bills that we're waiting for finalizing this proposed rules. And if that goes through, then the dates will be pushed forward to payroll deduction starting on July 1st, 2025, and benefits available on 2026 of July. And we'll keep you posted through our bi-weekly Compliance Corner article. But that's something to keep an eye out for if you have at least one employee working in Maryland. Some of the other states, they also offer state-based or private plan options. And the contents of the program are very similar to other states. So the information is there. So you can review after the webinar when you receive a copy of slides. The last state to hit is Minnesota. This is an interesting state as well in terms of the effective date. So it seems like the state has a reserve already. So the payroll deduction and benefits will become available to employees on the same date, 2026. And the benefits maximum amount for the employee will be able to receive through the Minnesota PFML is a bit more complicated. So noted there. And the maximum benefit will be announced in the future. And the maximum benefits duration is generally speaking 12 weeks per year. A combined maximum could be 20 weeks per year, which exceeds the PFML. And now hand it over to Maria.
Thank you so much, Yoko. So we know we gave you a lot of information, and we just want to talk about some key takeaways. So now that you have a better idea of how the federal and state leave should run with your company's short-term disability plan and your internal leave offerings, it's really important to take a look at your policies to make sure that they're compliant. Multi-state employers have the complex challenge of crafting comprehensive policies for all employees. So, this becomes really complex when you have employees in states that have no benefits at all, and then you have employees that have either a PFML or a PFL benefit or a statutory disability benefit. So it can get really complex. And as Yoko mentioned earlier, be sure that you're on the lookout for other state leave offerings when you're creating your leave programs. It's also important to note that as you craft parental leave policies, be sure that they're equitable for all employees who are bonding with a newborn, adopted, or fostered child. Because those parental leave policies, once again, as a reminder, should run after the period of disability, and parental leave should be for all employees. So that should be for all employees who either give birth, who adopt a child, or foster a child. That's what we mean by equitable. It should be for all those employees. And make sure that you require employees to file for any state benefits that they're eligible for. And that should be written in your policy. Number two, in order to prevent employees from stacking time, as we mentioned before, it's really important for employers to run all leaves concurrently whenever that's possible. And this should be stated again clearly in your policies. And as we mentioned, there may be times when federal and state FML may have varying definitions. So really be careful about taking a look at each leave request to make sure that you are not forcing an employee to take leave that they're not entitled to, and also making sure that you are providing leave that they are entitled to. Number three, if you're in any of the states with new PFML regulations, that will be going into effect in the near future, check out their website for information on what you need to do to prepare. Many of them have guidelines for employers, and some will even give you the option to sign up for email updates. I did that with Minnesota. So be sure to take a look at the state website to get the latest information. It's going to be important also that you communicate to your employees about these leaves early, and that you also take a look at the regulations and formulate your leave policies in advance. Again, things may change a little bit. New things may transpire, especially when a law has not gone actually into effect. But for the most part, they start to put out the regulations and you can actually stay on top of it. We provided some helpful links at the end as well. Be sure to stay informed of any new and upcoming changes, because there's definitely going to be more states on the horizon that are going to jump on this landscape. And of course, number 4, the state leave landscape is so complex. We speak to multi-state employers all the time and talk to them about what their options are. Many employers do not have the in-house expertise to understand or manage multi-state leave requests. And if this sounds like your organization, you're really not alone. A lot of employers that we're talking to today feel this way. But with the inception, of the remote workforce, many of our clients that were in 1 or 2 states find themselves in 20 or 30 states. So it's really not surprising that HR leaders are struggling. The good news is that there is a solution. Many employers partner with a leave administration vendor that can help to manage leave processing, communications, tracking, and most importantly, compliance. There are also a number of options available to you. So speak to your NFP consultant about it so they can help you. And lastly, of course, as always, be sure to seek outside counsel if you're facing complex leave scenarios. Human Capital Solutions can also assist you in formulating comprehensive and compliant leave policies and procedure documents. So we have some resources here that we thought we would share with you. We are not going to go through all of these, but you will be sure to receive the slides. We have a lot of different links that we use for this presentation that we thought would be helpful to you in many of the states that we reviewed today. And I'm going to turn it over quickly to Yoko to talk about some NFP resources.
Great, thank you, Maria. So we have a few publications that will assist you, and also so such as this publication quick reference chart. It has a list of states as well as each state's like summary, as well as other publications. And we are also in the pipeline for other scenario charts that you saw as well. And hand it back to Maria.
Thanks, Yoko. So we just want to make sure, you can always access Human Capital Solutions if you need help with formulating your company policies and procedures, or if you'd like to understand more about your leave administration vendor options. Human Capital Solutions is a consulting division of NFP. We work with all of our clients and prospects to provide solutions in the human capital space, anything related to HR, but we are doing a lot of work in the leave administration space, as you can imagine. You can certainly contact your NFP consultant, or you can contact me directly. You will receive a copy of these slides. And actually, I am going to turn it over to Amber to close us out.
All right, thank you, Maria. And thank you, Yoko and Shauna and Maria, of course, for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you'll receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us, and have a great day.